Hello everyone! Today we're going to talk about First Amendment, protected free speech, and its relationship with deportation, the current immigration atmosphere. So without further ado, let's get to it. I'm an immigration lawyer practicing about 7-8 years now. I first started off during the first Trump presidency. I'm familiar with different policies being implemented. This time around though, we are seeing very unique circumstances where current administration is taking a stance on arguably First Amendment protected speech and political activity. I wanted to take this opportunity to explain because I've been getting a lot of calls, inquiries. I wanted to put this reference video together so I can explain some of the basics that apply. First of all, unfortunately, immigration is as complicated as it gets. It is a very unique area of law. There are multiple agencies involved, multiple courts involved, so I'll try to explain my best. There are some high-profile cases. They are litigated with an extreme amount of resources because, public is watching those cases and they're kind of like test cases. The government is testing the legality of what they can and they cannot do. And I'm going to drop a link below so you can take a look at a very good article breaking down the basics for non-lawyers. But what I want to explain is when it comes to immigration enforcement, it is very complicated. That's why it is very confusing. Questions like, oh, am I a green card holder? Can I be deported? I don't have status. Can they revoke my status? What about a visa? Can I leave the country? Can I come back? These are the burning questions we've been getting a lot lately. Everyone's circumstances are unique, so if you need expert help, someone in my position to guide you through your options, please reach out. So let's talk about what is removal proceedings first. Removal and deportation are terms of art we use. There's another concept called inadmissibility. There is also another term that goes hand in hand with that, deportability. In terms of someone coming into the country, we talk about inadmissibility, something that's happened during admission, and again, this could be an admission to status. So someone comes into the country and they become a green card holder. When someone is in the country with status, we're not talking about inadmissibility. There's no admission. We're talking about deportability. I want to create that distinction first, right? In these high-profile cases, what's happening is most of the time, the government is arguing deportability. They're saying there are individuals, they could be in student status, they could be green card holders, that they are subject to deportation. They are deportable because of such and such. The biggest question here is, how do these removal proceedings happen? First of all, removal proceedings are of administrative nature. They happen before immigration judges, and immigration judges are lawyers employed by the Department of Justice within an agency called Executive Office of Immigration Review. So a majority of removal proceedings happens at an administrative level. There is a intersection because of the constitutional protections between federal courts, district courts, courts belonging to the judiciary branch of the government. There is an intersection. But general rule is, at some point in the early 2000s, the Congress was very clear on making everything administrative. So it used to be that there was litigation that happens at the district court level right after these removal proceedings, right after an immigration judge issues an order, namely habeas corpus filings. With different enactments at different levels, at some point in the early 2000s, that became a thing of past. Now, everything happens at the Court of Appeals level after the administrative process is over. I will try and walk you through. So, like I said, the government, another branch of the government, another agency, Department of Homeland Security, the enforcement branch, ICE, infamous ICE, prosecutes those cases. So, one hand of the government within the administrative branch is prosecuting. Another branch of the government, Department of Justice, is deciding these cases, right? Everything is happening at the administrative level. And the government, the ICE prosecutors, have to argue for removability or deportability. In this case, there's a very unique provision of the law that's being implemented. This is the law we are seeing in high-profile cases. Now, without getting too technical, what I can say is this law basically pretty much says someone's presence in the United States, if it's contrary to the US foreign policy, they are inadmissible or they are deportable. This unique provision is very controversial, and there is a reason for that. Let me try and break it down without getting too technical. So basically, the statute says if an alien, a non-citizen's presence in the United States is contrary, creates an adverse effect to US foreign policy, that alien is inadmissible or deportable. That alien should not have been granted a visa in the first place, or that alien can be deported, is the way it happens in the high-profile cases. Obviously, what happens when there are First Amendment protections? If there is political activity that falls within the First Amendment, freedom of speech, right? That's the million-dollar question. We don't know if this provision is constitutional or not. It's being implemented, but there is no binding decision that clearly says this provision violates the First Amendment or not. So in that sense, we're looking up to the Supreme Court to decide definitively what it means and how it can be implemented without violating First Amendment. So this is going to be really interesting. There are different lawsuits going on. These high-profile cases will be first heard by immigration judges. And now, if you ask me, an immigration judge, it's really tough to be in that position because they are an employee of the government, and then, their employer is bringing in a high-profile case, and it's really hard for them to take a policy stance that it contradicts that initial policy, like anti-Semitism. Like, we are going through really interesting times. What freedom of speech means, how it relates to anti-Semitism. I think this has been brewing for a very long time. Hopefully, the high courts will clarify everything. There will be a landmark decision that's going to clarify. I hope so. So we all can have some sense of predictability. Government can understand what they can do, and we can understand what is protected by the Constitution or not. But immigration judges are in a really tough position. And I think one of the high-profile cases, Mahmoud Halil, the judge, in fact, ordered removal, deportation. Now what happens is, the judge's decision is not final. There is a Board of Immigration Appeals. Within the OIR, Executive Office of Immigration Review, there's a body that decides these immigration judges' decisions. They are appealed. The first administrative appeal. The BIA is going to make a decision. Obviously, his lawyers appeal this case, and then BIA is going to make a decision. And after that decision, the next stop is, according to this early 2000 legislations, next stop is the Court of Appeals, not Federal District Court. Now, there are different legal challenges happening at District Court level. Some of these are directly attacking the policy, the Department of State's involvement in this provision I just mentioned, like foreign policy position. Obviously, these individuals' decisions will be making their way to the Court of Appeals and possibly all the way up to the US Supreme Court. Now, the million-dollar question for these individuals are, do they go through this process while they are in custody or not? That's a very important concept of immigration law and practice. Detention. Normally, people go through removal proceedings, these hearings before the immigration judge, either in detained setting while they're in government custody or when they're free, when they're, outside going on with their lives. The majority of cases are being handled in the non-detained docket, non-detained setting. And right now we have approximately 3 million cases. Most of them are linked to those who crossed the border in the past few years. In these cases, the first legal position that needs to be taken by the immigration judge is if these individuals are going to be released on bond or not. Now, bond is, unfortunately, in the immigration setting, also very complicated. There's something called mandatory detention, and there was a recent piece of legislation called Laken-Riley Act that brought about an expansion of mandatory detention. Mandatory detention is someone in our position cannot argue bond for our clients because they are subject to mandatory detention. If you're watching my channel, you know that Laken-Riley Act video I put together, so you can go back and check. So detention, bond. If someone is subject to bond or not. If someone is subject to mandatory detention or not, can they be released on bond or not? So that's the first question. Because there are constitutional arguments here, their custody can also be challenged at the federal district courts by way of habeas corpus. So now habeas corpus is a very important tool of American law, common law, and it challenges someone's custody without getting into, why they're in custody, if there are any constitutional violations or not. So habeas corpus is a very important tool. Obviously, some of these challenges are being brought under the First Amendment grounds. This is going to be directly related to higher court's ruling of where the First Amendment, freedom of speech, comes into play. So that's also going to be very interesting. What you can do at one front is try and, if you're targeted, if you think of being targeted, you can go ahead and try and argue for bond. Or if you're expecting something like this, what I recommend my clients is you can also maybe look into coming up with a prospective habeas corpus petition ready. We can look into your circumstances, we can analyze your circumstances and put together an argument that's ready. So the moment you're taken into custody, we can file that petition to challenge your custody. Like I said, immigration court happening at one front, habeas corpus proceedings happening at the district court level, very complicated to say the least. Obviously, this is going to be a very interesting time. American democracy is being tested. My job as a lawyer is I'm an officer of the court. I'm here to uphold the law. That's what I'm going to keep doing. If you think you need help, don't hesitate to reach out. Our contact information is down below. If you think this information is going to help someone, please feel free to share it with different mediums and different contexts. This information, this valuable information, reaches more people that might need it. Thank you for listening, and please keep in touch.